Okay, so today we're going to really zero in on something that I know is super important to a ton of you out there listening. And that is, how much can a landlord in California actually increase the rent?
Right.
Like if you're renting in California, those rent increase notices can feel like they really pack a punch, right?
Yeah.
And figuring out all the rules around those notices can be a bit of a headache.
Uh-huh.
So we're going to try to break down some of those regulations today and make things a little clearer.
Yeah, absolutely. I mean, for California tenants, really getting the ins and outs of how much your rent can be increased. It's not just about knowing your rights on paper.
Right.
It's fundamental to your financial stability, you know?
Totally.
Rent is often a huge part of people's budgets.
Oh, yeah, for sure.
So clarity on this stuff is super important.
So that's why we're doing a deep dive today into the Tenant Protection Act of 2019. You might know it as AB 1482.
Oh, yeah.
This is the main thing that governs rent increases in California, and it offers some really important protections. But like any set of rules, there are exceptions, and it's crucial for you to understand those too. So our goal today is to really unpack what limitations AB 1482 puts on rent increases.
Okay.
And to be crystal clear about which properties are covered, and just as important, which ones aren't.
Yeah.
You want to make sure you have a solid understanding of your rights as a renter in California.
I think what's really interesting here is that AB 1482, it sets this statewide baseline for, tenant protection.
Uh-huh.
But it's not like a one-size-fits-all situation, right?
Nah.
The details of which properties are actually covered and which ones are exempt, that they can really make a big difference in a renter's experience.
Absolutely. Now, before we jump in, I just want to mention, if you're in Orange County, Riverside, San Diego, or Los Angeles, California, and you're dealing with any tenant rights issues, like maybe an eviction, or you have questions about your lease, it might be helpful to know that the Martinez Law Center in Santa Ana specializes in these areas.
Okay.
You can find them online at martinezlawcenter.com. All right, let's get down to basics here. What is the general limit on how much a landlord can raise the rent under AB 1482?
Okay, so the general rule with AB 1482 is that rent increases each year. They're capped at the lower of either 5% plus the local consumer price index, or CPI,
CPI, okay.
or a total of 10%. So that CPI, it's included to take into account inflation in your area.
Makes sense.
It helps make sure that rent increases are at least somewhat tied to, the changing cost of living.
Okay, so it's like a two-part calculation with a ceiling.
Got it. Exactly.
So let's say inflation is pretty high where I live, the CPI is 8%.
Mm-hmm.
My landlord can't just tack on that whole 8% plus another 5% on top, right?
You got it right. So in that case, even though 5% plus 8% would equal 13%, the overall 10% cap kicks in.
Right.
So the most the rent could go up is 10%.
Okay.
On the flip side, if the CPI is lower, let's say 2%, then the maximum increase would be 5% plus that 2%, so 7% total.
Got it. So it's always the smaller of those two numbers.
Exactly.
Makes sense. It seems like it's designed to give tenants some predictability.
Right.
While also acknowledging that the economy, does change.
Mm-hmm.
Now, what about a landlord who tries to get around this limit by doing a bunch of smaller rent increases throughout the year?
Right. Well, AB 1482, it actually regulates how often rent can be increased.
Okay. Yeah.
Landlords, they can't increase the rent more than 2 times in any 12-month period.
Right.
And importantly, the total of all those increases within that year can't go over that limit we talked about.
That makes sense.
That 5% plus CPI or 10%, whichever is lower.
Right.
This prevents landlords from kind of sneaking in rent increases to get past that yearly cap.
Yeah, that's a really important protection. I mean, otherwise it could be like death by 1,000 cuts.
Right.
For renters' budgets.
Yeah.
Okay, so what about if a landlord does decide to increase the rent, how much warning do they have to give legally?
So the law sets minimums for written notice.
Okay.
If the increase is 10% or less, the landlord has to give at least 30 days written notice.
Okay.
But if it's more than 10%, then the tenant gets a longer notice, at least 90 days.
Makes sense.
These notice requirements are there to make sure tenants have enough time to either, prepare for the higher rent or to look for other housing options if they need to.
All right, so those are the general rules under AB 1482.
Right.
But we mentioned earlier, not every rental in California falls under these rules. So let's get into some of the key exemptions. What's the deal with new construction?
Yeah, so this is a big one. Under AB 1482, rentals that got their certificate of occupancy within the last 15 years, they're actually exempt from the rent cap.
Okay.
And this 15-year window, it works on a rolling basis.
Rolling basis, that sounds a little tricky to keep up with.
Yeah.
Can you give us an example of how that works in real life?
Sure. So imagine a building that was finished and got its certificate of occupancy on, let's say, July 1st, 2010.
Okay.
That property, it would have been exempt from AB 1482's rent cap until July 1st, 2025.
Right.
And then on that date, the unit would become subject to AB 1482, assuming there aren't any other exemptions that apply. The rolling part just means that each year, a new batch of properties that were built 15 years earlier, they'll move out of that exemption period, and they might then fall under the law.
Okay.
So this exemption, it's meant to encourage new housing development.
Right.
By giving developers more flexibility in those early years of a property's existence.
Makes sense. It's like a temporary window of flexibility to encourage those new housing projects.
All right, what about single-family homes and condos?
Yeah.
Those rules seem to have some specific conditions.
You're right. There are some definite strings attached to the exemption for single-family homes and condos.
Okay.
Generally, these types of properties are exempt from the rent cap.
Okay.
However, this exemption does not apply if the property is owned by a corporation,
Right.
a real estate investment trust, or REIT,
Okay.
which is basically a company that owns and often operates income-producing real estate, or an LLC where at least one member is a corporation. So the way the ownership is structured is the key thing here. So if a single-family home or condo is owned by like an individual, a married couple, or smaller LLC where all the members are individuals, it could be exempt?
Exactly. But here's something super important for renters. Even if the ownership structure qualifies the property for this exemption, the landlord has to give you the tenant written notice.
Okay.
Saying specifically that the property is exempt under this part of AB 1482.
So that written notification is really crucial. Even if the property could be exempt based on who owns it, the landlord has to actually tell me in writing for the exemption to be valid.
That's exactly right. Without that specific written notice from the landlord, the exemption doesn't just automatically kick in.
Right.
This is a really important protection for tenants. If you don't get that notice, you should assume that the rent increase limits in AB 1482 do apply to you.
Got it. That's a huge distinction that renters need to be aware of. What about affordable housing? Are those properties treated differently under AB 1482?
Yes. Rentals that are specifically designated and restricted as affordable housing for low or moderate income households, usually through a deed restriction or some kind of recorded agreement, they're generally exempt from AB 1482's rent increase limitations.
Okay.
The reason for this is to let these dedicated, affordable housing programs operate the way they're supposed to.
Makes sense.
According to their own financial models and rules, which often already have their own rent restrictions and guidelines.
Right. You wouldn't want a general statewide cap to mess with the ability of those affordable housing initiatives to work properly. Are there any other major exemptions that California renters should be aware of?
Yes. Another important one is owner-occupied duplexes.
Okay.
If the owner of a duplex lives in one of the units as their main residence, then the other unit that's rented out is exempt from the rent cap in AB 1482.
Right.
There are also some more specific exemptions, like for dorms that are owned and operated by schools, and for rentals that are already under a local rent control ordinance that's stricter than what AB 1482 lays out.
Okay, so it sounds like AB 1482 sets like a minimum level of protection for tenants when it comes to rent increases.
Right.
But local governments can sometimes have even tougher rules in place. How does that actually work like that, back and forth between state and local regulations?
Yeah, so AB 1482 basically acts as like a minimum standard across the state.
Right.
If a city or county has its own rent control ordinance, that puts more limits on rent increases, like maybe a lower percentage cap on yearly increases, or offers tenants broader protections than AB 1482, then that local ordinance is the one that matters.
So as a renter, it's always a smart move to check if my city or county has any local rent control ordinances, because they might offer me even more protection than what's in AB 1482.
Exactly. We always suggest that renters check out the resources provided by their local government, like their official websites and housing departments, just to see if their rental is covered by any local rent control rules that could give them even stronger protections than AB 1482.
All right. This is all really important for California tenants to know.
Yeah.
So what's the main takeaway here for renters? Why should they care about all these details about AB 1482 and its exceptions?
Understanding these regulations, it really gives you power as a tenant.
Okay.
Knowing whether your rental is covered by AB 1482's limits on rent increases, or if it's one of the exempt properties, It's the first step in understanding how much your landlord can legally raise your rent.
Right.
If your place is exempt, your landlord isn't bound by those statewide caps.
And if I'm a tenant and I get a written notice from my landlord saying my place is exempt from AB 1482, what should I do?
You need to really look over that notice.
Okay.
Make sure it clearly explains why they're claiming the exemption.
Right.
Especially if it's because of the ownership structure for a single-family home or a condo.
Okay.
If you're unsure if the exemption is actually valid in your situation, you need to take some extra steps to figure that out.
What kind of steps are we talking about? What can a tenant do if they're not sure about their unit status under AB 1482?
First, try to find out how old the building is.
Okay.
You can often find that in your lease or in public records kept by your county assessor's office.
Right.
Second, go over all the notices you've gotten from your landlord about rent increases or any exemptions they've claimed.
Got it.
If you've done all that and you're still confused or you think your landlord might be claiming an exemption incorrectly or breaking the rent increase rules, it's a good idea to get some help.
Yeah, that makes sense.
You can reach out to local tenant rights organizations. A lot of them operate all over California.
Yeah.
And they offer guidance and support to renters and for specific legal advice, or if you believe your rights have been violated, talking to a qualified tenant attorney. Like the professionals at the Martinez Law Center can give you personalized guidance based on your specific situation.
Good to know.
Their website is martinezlawcenter.com.
Okay, so just to be totally clear, the info we're giving today is for educational purposes, and it shouldn't be considered legal advice. For any specific legal questions or concerns, you should always talk to a qualified attorney.
Landlord-tenant law, it can be complicated.
Yeah.
And the specifics of your situation, they might need professional legal help.
All right, so as we wrap up this deep dive, what's the most important thing our listeners should remember about rent increases in California?
The key thing to keep in mind is that while AB 1482 does put a general limit on how much rent can be increased each year in California, there are some pretty big exceptions to that law.
Right.
Figuring out if your rental is covered by AB 1482 or if it falls under one of those exemptions, that's the crucial first step.
Okay.
That's how you understand the legal limits on how much your rent can go up.
That's a really clear and actionable takeaway.
Right.
And it makes me want to ask you, our listener, what kind of property do you rent?
Right.
Has your landlord ever given you a written notice saying they're exempt from AB 1482?
Good question.
And do you know if your city or county has its own rent control ordinance that could offer you extra protection?
Yeah.
These are all super important questions for California renters to think about.
By understanding these regulations, you're in a better position to have informed conversations with your landlord and to seek help if you think your rights as a tenant have been violated.
Right.
And again, if you're a tenant in Orange County, Riverside, San Diego, or Los Angeles, California, and you're dealing with an eviction or any other tenant rights issues, the Martinez Law Center, they focus on these areas.
Great.
And they can be a valuable resource. You can find them at martinezlawcenter.com.
Awesome. Thanks for shedding light on this important topic. We'll definitely be back to explore other aspects of tenant rights in California in future deep dives.
Sounds good.
Until then, stay informed and know your rights.
Absolutely.
Thanks for listening.
Thanks, everyone.
Call now 714-442-9741. Thank you.